All these musical concerts you've witnessed or you participated in, if any of them involve performance of other person's musical work or songs, then the owners of those songs are entitled to. Seasons are always characterized by a lot of events. A common event you see are musical concerts. And those of you who are in Ghana, you probably have been to Kofi Kinete's makit.legal concert. And those of you who are not Kofi Kinete's fan or are fans of Stonebwoy, you probably went to the Bing Festival. And all these videos are circulating. Those who are fans of Black Sheriff or Black Co, as some of you call him, probably have been to his show, which is the Zama Disco. And I believe you were there. All these events are largely live performances where people perform songs or musical works, as a lawyer will call it. People buy tickets, get to pay gate fees and all of that just to have access to the event center and participate in the Bing Festival, the Made in Tadi, the Summer Disco and what have you. I mean, it's important and it's ideal for some people. I'm here to talk about the legal matters of concern that I think you need to know about. And I'm excited to share that with you. Stay tuned and let's do that. I am Godin Selassie Dakbo, and this is Make It Legal. Make it legal. Well, so we reviewed some of the videos and we made few observations, and what we have concluded is that all of these events are live performances or are concerts that are characterized by a lot of public performance of copyrighted songs, and the law has a lot to say about that. If at these events, for example, Stonebwoy, performs another artist's song at that event where he has received money from people to come, to listen to his songs and dance to it, if he happens to perform other people's songs, are those persons able to have some legal action against him, or they have some stake in the money he's collected at the event? These are important legal issues, and I'll discuss all of that with you. Now, the law will always have a remedy or two to address issues of that nature, issues having to do with broadcasting or performing other people's copyrighted songs at events. It could be live performances like Zama Disco or the Beam Festival and what have you. All these events are characterized by live performances, and other person's songs are performed by other artists. What you need to know is that there is a law in this country, which is the Copyright Act of 2005 at 690. Now, this law provides in section 37 that persons who are owners of copyrighted songs or copyrighted musical works are entitled to be paid royalties from the public performances of their songs. Royalties are simply payment that you give to the owner of a musical work or copyrighted work for using his or her work. So that is money. The key condition is whether or not those songs are performed at a public place, or was a public performance, or was broadcasted by means of radio or speaker or what have you to the public. And when that is the case, then the owner of the copyrighted song is entitled to royalties. Some of you may ask whether or not, do I just get up and walk to Stonebwoy or to Kofi Kinata and say that, give me 50% of the money you've made from this particular concert because you have played my song for 5 minutes or for 10 minutes and people, were dancing to it and all of that? Is that how it is done? Not necessarily. Apart from the person just, getting in touch with the producer or the one performing the show to claim his royalties, the law also provides for what we call collective administrative society, where a group of actors or producers or owners can actually come together to form an association that would collectively represent them to collect, royalties on their behalf and distribute to them. And that is permitted by Ghanaian law as well. So we could have a lot of producers and artists of musical work as a kind of intellectual property. They can come together to form an association that will represent their interest and also collect the royalties on their behalf and distribute to them in accordance with their own internal rules as well as the regulations of the country. So the Copyright Act of 2005, also in section 49, provides for that possibility where the authors or the owners can form the associations. And in Ghana, we have an organization which is called a GAMRO. It's the organization that comprises over 4,000 authors and producers who have come together to set up that entity to collect and distribute royalties on behalf of the owners of copyrights. A GAMRO refers to the Ghana Music Rights Organization. It is a company they registered with board of directors who would, direct the functions of the organization. So GAMRO is one of such entities that represent the authors and owners of copyrighted musical works, and are mandated by their internal regulations and by the law to collect royalties and distribute them to the members. It may interest you to know what exactly amounts to public performance of a particular copyright protected song. Once it is performed to the public and for some commercial benefits, the law deems it as a public performance, and public is public. Public is, some degree of extension to others beyond the family who listen to the show, and they are coming purposely because you are performing the show. So the public here is the general public as we understand it in other items. So when there is such a live performance or public performance of a copyright protected song or musical work, the owner is entitled to royalties. It may surprise you to know that if you perform a copyright protected song, even just at a bar or at a restaurant or at a hotel, it's amount to public performance of that particular song. Let's even imagine you going to buy the cassette or the disc that has a song. You bought that yourself, brought it home and put it in your own musical device before you play it at the restaurant. Once you play it to the public or to the people who come and buy at a restaurant, you are playing to the public and you are expected to pay royalties to the owner for playing that song in the public. Is it that interesting? There was an old law which has been replaced by the current law. The provisions in that old law and this current one are virtually the same. The way the law view public performance is similar to how it is being viewed under the current law. So there's this case that's happened between the National Drinking Bar Operators Association and then the Copyright Society of Ghana. Then the Copyright Society of Ghana demanded of drinking bar operators to pay royalties to them, who were mandated then to collect royalties on behalf of their members. So they approached the drinking bar operators that they should pay royalties for using the songs or for playing those songs as part of their business and to the public in a very simple term. So, and they objected to paying it. And what were their reasons? They were simply saying that no, we bought the cassettes and we are playing it as part of our business because that is where we bought it. We even paid tax when we bought this item. So do we pay royalties again after we have paid tax after buying the cassette that has the song? So they say they won't pay. It's not fair. So one Afre, who is the chairman of the National Drinking Bar Operators Association, took the Copyright Society of Ghana to court and said the court should declare that they don't have any right to collect royalty from bar operators or restaurants. And guess what the court said? The court did, agreed with the bar operators that yes, they are not supposed to collect royalties again and all of that. But the Copyright Society of Ghana disagreed with the court, which was the High Court, of course. And the High Court decision was challenged on appeal. The Court of Appeal interestingly said that the playing of musical works or songs through a radio cassette at a bar, hotel, and restaurant amount to public performance of the song. And the owners of those songs are entitled to payment of royalties for the public performance of their songs. The Copyright Society of Ghana was declared to have the legitimacy or the right to approach bar operators to obtain payment of royalties for performance of their member songs, at those places, restaurants, bars, and hotels. But why would the court say that it amounts to public performance of the song? The court said that since it was the playing of a music to persons in the public who were coming to buy the products of the restaurant, the bar, or the hotel. It is a communication of the musical work to the public, and therefore you are broadcasting somebody's intellectual property. And even though you bought it and paid tax for it, you bought it so you can use it personally. But if you want to use it on a commercial basis, then the rule is that you're supposed to pay royalties to the person who owns it, and that is the law. So all these musical concerts you've witnessed or you participated in, if any of them involve performance of other person's musical work or songs, then the owners of those songs are entitled to receive from them payment of royalties for those performances, because they are public communications of the person's copyright work to the public. And obviously, the law is quite clear that they deserve some payment as a royalty for the performance of their song. I believe we pick a lesson or two from this one, as we still enjoy the festive season and we are excited about all the concerts we are participating in them and dancing left, right, center. This is a law that hovers around whenever you are at that concert. It is there whenever an artist is called to come on stage and he comes on stage, begins to sing any song at all. This law begins to say, okay, I am applicable. I am applicable. I call for royalties to be paid to so and so, who is the owner of the song you are performing, which is not your song. I am Gordon Selassie Dakbo, and this is Make It Legal. Make it legal.